Hello, everyone. My name is Cindy Waterson. I'm the principal attorney with Waterson Huth Associates, and we are vendored contract attorneys with Lanterman Regional Center. I'm doing this presentation in coordination with the KYRC to provide some training presentation to our families. So I'm obviously not giving any legal advice here, but this is just an educational presentation. So what I want to talk about today is transitional planning. As your child turns 18, there's lots of things to think about. Your child, when your child turns 18, they suddenly become a full person. And it's something you may not think about, but a parent really loses a lot, if not all, of your rights when your child turns 18. Your child is presumed to have competence at that time to make decisions on their own, and the law provides for that presumption. So this is why you need to plan. You need to make sure that your child's quality of life is as good as it can be, and you want to protect them as much as possible while still giving them as much independence as freedom as possible. So some of the benefits of planning: to provide for their financial security. So hopefully they will be eligible for public benefits. That you may want to think about leaving your estate to your child or a portion of your estate. There may be other members of the family, grandparents that want to provide. So how can you provide for your child's financial security? There's a lot of factors to think about, whether or not they're going to be able to work, perhaps work part-time, or perhaps your child will be unable to work at all. If your child is unable to work, you'll want to look at public benefits, the most common being SSI and Medi-Cal for our kids. And these are means tested, which means that they're not allowed to have assets in their own name. So that's something we need to look at. To select the proper team to provide lifetime management. As your child's growing up, you have a really good circle of support. You have an IEP plan. You have your IPP plan. So you've got the regional center, you've got the school, you've got family. Your child has a really good circle of support. But as they turn 18, that's going to need to be tweaked a little bit. Maybe bring in other people. So that's something to think about. To plan for housing. Your child may be living with you right now. They may be considering moving into their own apartment or a group home. You may believe that your child will always live with you, but at some point you may not be able to provide that assistance for your child anymore. And frankly, at your passing, what will happen to your child? These are really difficult things to think about. But it's so important to plan so that when that happens, when the inevitable happens, it's not a crisis in the family. To provide ongoing system of advocacy. You are absolutely your child's best advocate. But after you're gone, who will be that substitute advocate? Who are you grooming to start doing that for you? To plan for caregiving needs. When you're unable to physically give those services to your child, who else can you who else can you hire, or can you get to provide those needs? To coordinate extended family planning. Do you have an estate plan? Perhaps a trust for the family, perhaps a special needs trust for your child. It's time you want to think about coordinating that. To protect the beneficiary from predators. Are there people in your child's life that can add that protection? Either a conservator, an agent under a power of attorney, a trustee, different people that can help you when you're not able to do that. And then finally, to preserve assets for other heirs, meaning, do you want to leave all your assets to your disabled child, or do you have other children that you're going to want to leave assets to as well? And how do you make that division? If you have no plan, then a probate may be open for you, and the assets will all be divided evenly among your heirs. So your disabled child will be treated just like all your other children, and perhaps that might not be the best thing for them if they need a special needs trust. That wouldn't be provided. So that's a lot of things right there to think about and to answer the question, why plan? So now that you're thinking about why we need to plan, and hopefully you're convinced that you do need to plan, it's time to start creating an effective plan for your child. So what steps can you take today? Think about, a lot of these we've talked about already, but where will your child live? With whom will he live? What type and what level of care? Can they look at a group home, at an apartment of their own? Do they need more care, such as a group home or assisted living type situation? Who else will be involved in their life? What kind of lifestyle is desired? Does your child perhaps need a very structured situation, or are they very creative and they need more outlets for that? Excuse me. And then what will they need for future challenges? What can you do today? One of the first things I always advocate for is to create a memorandum of intent. Excuse me, this is very easy. It's something, it's a document you just sit down and you start writing and you sign it. It's very informal, it's not legally binding, but it lays out your goals and expectations. It details what you want for your child. I always tell people, think about what your family values are and put that in your memorandum of intent. This is who our family is. These are our values. This is what's important to us, whether that's church or being out in the community, whatever that is, to detail that. And then the important people in your child's life. So different family members, family friends, clergy. List those people. And then list what your goals are for your child, that you want to see them in what kind of living situation. You want to see them working or volunteering or participating in creative endeavors. So this is just very personal, what your goals, what your expectations, what your wishes are for your child. And this helps after you're no longer able to make these things known. This helps other people to know what it is that you want for your child. And generally, you write this out, you put it in a binder with all your other important papers. If you have a trust or your will, just put that in there. So other family members, trustees, caregivers would have access to this and would have a better understanding of how to work with your child to fulfill your dreams. What other steps should you take? One thing that's really kind of difficult, but after you have your memorandum of intent, you have a better idea of the lifestyle that perhaps you want to see your child living in. So sit down and think about what that's going to cost. So your child may be, what kind of income will your child have? They may be eligible for SSI, Social Security, Supplemental Security Income, SSDI, Social Security Disability, regular Social Security, earned income, so they have a job, a part-time or full-time job, or unearned income. That would be gifts, inheritance, this sort of thing. So SSI is, I think we talked about earlier, is means tested. Your child can't have a lot of assets if they're eligible for SSI. SSI is received, your child is eligible for SSI if they have less than $2,000 in assets and they are unable to work. and have never worked. SSDI is, your child is eligible for that if they have a work history already. So they have enough they have enough work history credits through Social Security that they will get this disability income. They're unable to work because of their disability, but they have a work history. SSDI is not means tested. They can have other assets and still receive SSDI. Social Security, of course, is a program that you've paid into as you've worked. But most common for our regional center clients is SSI. In 2020, the SSI amount is $942. That's the federal plus a California supplement. So if you estimate that your child right now anyway would receive about $940 a month in SSI plus Medi-Cal. Then you look at their expenses. How much is housing going to cost? Rent, food, transportation, medical expenses, recreation. SSI is considered to pay for housing, shelter, and food. So those two are supposed to be paid for by the $942 in SSI. There's extras, transportation, medical. There's always some medical expenses that Medi-Cal does not pay for, and recreation. Then you have to figure out how that shortfall will be met. Here is a form that you can use, and it's nothing special, but it's something to look at to, as you can see on the left-hand column, to look at today, what are these costs? So your child's share of costs, let's say for your housing, you have a rent, and his share of cost is $200. And then utilities, what's his share? Cable, child care, special needs. Do they need assistance? Do they need respite? Do they need an aide to come in? Advocacy services. And then look at, in a lifetime, what is that going to be as your child ages? Do you think that they may have more needs, less needs? There are life planners out there that can be hired that helps you put this plan together. So they will look at, with the cost of living increases, what your child will need depending on their anticipated lifespan. So that's kind of complicated, and most people don't go through this, but it's a good exercise to think about how much income your child really needs and what they may need in the future. So in that, you may be thinking, well, my child's going to need more assets than what they're receiving in just SSI. And one way to accomplish that is to design a third-party special needs trust. Third-party special needs trust, is established by the assets of someone other than your child. So this can't be established with your child's assets. This is a gift from you, a gift from grandma. So let's say that you draft and you establish this third-party special needs trust, and you make a gift to your child. You establish it with $500. Your child has $500. He doesn't have access to it. There will be a trustee that is nominated, that is appointed as the trustee of this trust. And that person, that trustee, is the only one who really has the ability to manage this money. It's fairly informal. You do have to notify your public benefits that this is out there. Excuse me. But it's a good way to have someone else out there managing things other than yourself. Of course, in the initial, you can be the initial trustee, or you can appoint someone else to do so. Going back a little bit, we talked about when your child turns 18, the law says that they are presumed competent to make decisions on their own. Many of our clients do need some assistance, and in fact, all of us need assistance at some point or another. And when I'm doing estate planning for anybody, I always recommend that they sign an advanced healthcare directive. And what that is a document where you appoint an agent to act for you if you're unable to do so. So the example I always give is if you walk outside my office today and you get hit by a bus and you're in the hospital, who's going to make decisions for you? Who's going to talk to the doctor for you because you're unable to do so? So if you sign an advanced healthcare directive, you're appointing an agent. It could be your husband, it could be an adult child, it could be a good friend, and this person will make decisions for you and access medical records if you're unable to do so. Now, excuse me, in a directive or a power of attorney, they act the same. The person is acting for you. So if you do not want a surgery, but you're unable to talk for yourself, your agent really needs to tell your doctor they don't want the surgery. So you're acting for them. Not in their best interest, but what you know that they want. And in our situation, we need to think first, though, does your child have the capacity to understand this type of a situation? In other words, does your child understand that by signing this document, he's giving you some rights, and that there are consequences to signing this document? So if it's not a real high bar, but if your child can understand that he's giving this right to you and what the consequences of that are, then he could sign an advanced healthcare directive and power of attorney for finances. If your child does not have capacity to understand what he would be signing, then you may want to look at a conservatorship. A conservatorship, first off, in the slide it says conservatorship and guardianship. In California, if we're looking at an individual over the age of 18 or over, we're looking at a conservatorship. Some states call that a guardianship, but in California we call it a conservatorship. In California, a guardianship is if you are unable to care for your child who is under 18 and you need someone to take over. That's a guardianship in California. So if a parent or another adult wants to help your child to make financial decisions, it would be a conservatorship. And in California, we have what's called a limited conservatorship, and that's specifically for people who are eligible for regional center services. And in a conservatorship, you can make many decisions for your child, and by imposing a conservatorship, you are then acting for that person's best interest. So even if the person disagrees or objects, you may remember we talked about, the surgery, if your child didn't want the surgery. With a conservatorship, you're acting in their best interest. So if you believe it's in their best interest to have the surgery, a conservator can override the decisions of the individual. And this is done by a court. So in an advanced healthcare directive, there's no court involvement. It's a document that is signed by your child, and it doesn't have to be filed anywhere. That's just between you and your child. A conservator has to be granted by the court and is then court supervised. So when we talked about the third-party trust, those were assets, you may remember, those are assets that are from someone other than your child. What if your child has assets? So perhaps there was a medical malpractice settlement that your child received some money, or grandma left an inheritance and left $50,000 directly to your child. These are now assets in your child's name. If it's more than $2,000, your child could lose or be restricted by their SSI and their Medi-Cal. So one way to protect his public benefits from these extra assets is to establish what's called a first-party special needs trust. And first-party means that it's assets of your child. And by the establishment of a first-party special needs trust, it maintains your child's eligibility for public benefits. They can continue to receive SSI and Medi-Cal and still have this money. It can be established by your child if your child has capacity, by a parent, a grandparent, a legal conservator, or the court. It must be for the beneficiary's primary benefit. That means that if we have grandma's $50,000 in this special needs trust, the entire family can't go to Europe on that $50,000. It has to be primarily for the child. And the reason is, if you think about it, your child is receiving these benefits, from the government because of their disability. So, we don't want, the government needs to know that any assets in a special needs trust are for the beneficiary and not, not paying for everyone. It has to be for someone under the age of 65. And then one of the big differences between this and the third-party special needs trust is the state must be reimbursed from the trust for any expenses that Medi-Cal has paid for your child during their lifetime. So if your child passes away and there are still assets in the first-party special needs trust, Medi-Cal has the right to say, we have paid out $100,000 in services for your child during their lifetime, and so we want a reimbursement from whatever money is left in the special needs trust. So the third-party special needs trust that we talked about before does not have that provision. There's no payback provision. But in a first-party special needs trust, there is. So there's some restrictions here, and if this type of trust is established by the court and through a conservatorship, then there will be court supervision. So this could be more difficult to administer. You may have court supervision, you have the state payback provision, but if you think about it, it has there are funds available to your child to meet needs that their public benefits are not meeting. So it's still a really, really wonderful thing for them. One of the things about this special needs trust is your child doesn't have access to it. Again, a trustee is appointed to manage the assets. So that kind of gives you an overview of things to think about as your child turns 18. Do they have the capacity to make some decisions on their own, and maybe the protection of durable power of attorney and a durable power of attorney and advanced health care directive would be probably enough to protect them and advocate for them. They may need more protection under a conservatorship. And then, again, look at your own estate plan and think about maybe adding a special needs trust to that, memorandum of intent for your child, and think about the lifetime of your child. There will be a time when they're going to need help when you're not around, and how do you prepare for that now? So, obviously, this is a video. We can't take questions. But if you email me or email KYRC, or probably best your SC, I'm sure we can get those questions answered. So thank you very much. I hope you've learned something from this.